There's a reason most history teachers skip this chapter. Roman masters had a legal technique that let them kill slaves without punishment, but do it the wrong way, and it's murder. We're exposing the 8 things owners legally couldn't do, the brutal loophole that made those rules meaningless, and why this system survived almost a millennium. This will change how you see ancient Rome forever. For most of Roman history, masters held near total power. The law called an enslaved person property, a tool with a voice. In early Rome, when households were small and masters worked beside a handful of enslaved people in the same field, eating from the same pot, cruelty had natural limits. Proximity mattered. A person determined to flee could disappear over a hill into the next valley before dawn. That risk alone restrained some masters more than any law. But Rome outgrew that world. Conquest flooded markets with captives, estates swelled, urban workshops multiplied. The bond between owner and individual worker thinned to nothing. The economy ran on coerced labour, and the law did almost nothing to stop what happened behind closed doors. People point to the censors, magistrates who could reprimand citizens for scandalous behaviour. Here is the truth. Their power was a right, not a duty. They ran no household inspections. Their office was not even continuous. Across the entire Republic, we have no confirmed case of a censor protecting a slave. If it happened, it left no trace. Yet the Roman state always cared about one thing above all: public image. When cruelty became theatre, it could backfire. Remember that banquet? The equestrian Vedius Pollio ordered his slave thrown into a tank of lampreys for breaking a goblet. Emperor Augustus was there. He stopped the execution, freed the man, and ordered every remaining goblet smashed. That was not a new law. It was a message. Spectacular violence in front of the elite could stain the host and embarrass the city. Keep your discipline inside. Do not make a spectacle of it. But here is what Augustus did not say. What happened inside, away from the emperor's gaze, stayed invisible to the law. So when did Rome finally draw legal lines? The answer will surprise you, because the first rules had nothing to do with mercy. Around the turn of the era, narrow regulations appeared, and they began with managing the citizen body, not protecting the enslaved. Under Augustus, the Lex Fufia Caninia and Lex Alia Sentia limited mass manumission and set age thresholds. A master could not free dozens of people by will to create instant citizens. An enslaved person often had to reach a certain age to gain full status upon freedom. These were population control tools, but they sketched the edges of a system the state wanted to regulate. Claudius cracked the wall from a different angle. If a master abandoned a gravely sick slave to avoid medical costs and that person recovered, the law granted freedom. Claudius also required masters to bury their dead. Refuse and a third party could handle burial and sue to recover costs. Modest guardrails, but they carried a message. Ownership came with minimum duties. Abandon the sick or leave the dead to rot, and the state would intervene. For the first time, Rome said your power has limits when you try to evade basic responsibility. The clearest statutory boundaries arrived in the 1st and 2nd centuries, and they reveal exactly what Rome feared most. One law required a judge's approval before sending a slave to be killed by wild beasts in the arena. Without judicial oversight, that punishment was illegal. Notice what the law targeted: not severe discipline, but a specific public spectacle that crossed a line. Later, emperors banned castration outright. Domitian condemned it. Hadrian reinforced the prohibition. These acts did not create rights. They drew a hard boundary around practices Rome chose to forbid. Then came the rules about killing, and this is where Roman logic twists into paradox. Under Antoninus Pius, unjustified killing of a slave became punishable. A master could face sanctions and pay damages, as if he had destroyed someone else's property. The lens remained economic, but the state now had a lever. A century and a half later, Constantine hardened that rule. A law of the early 4th century allowed killing of a slave to be prosecuted as murder. That sentence looks simple. Its meaning depends on one word: intent. Here is the line Roman jurists drew, and it defined everything. If a master intentionally stabbed, hanged, threw someone from a height, or fed them to beasts, that intent marked the act as murder. But if a slave died under what Romans considered customary punishment, severe whipping, for example, authorities often did not prosecute. To modern ears, that sounds like a glaring contradiction. To a Roman official, it separated criminal murder from household discipline. It preserved the master's authority inside the home. The result was a narrow channel of prohibition inside a vast river of permitted coercion. You could not stab your slave with murderous intent. You could whip them to death during punishment. Now we need to talk about the private contracts that travelled with enslaved people, because they reveal exactly where Roman society drew its sharpest lines. 4 standard formulas appear repeatedly. Ne manumitito, do not free this person. A seller might add it for an elderly enslaved person to keep them supported rather than pushed into precarious freedom without means. Ut manumitatur, you must free this person after a set time. Ut exportatur, remove this person from the city and do not bring them back. Even after freedom, return was dangerous. Ne prostituatur, do not force this woman into prostitution. These clauses bound all future owners. If a woman was resold, the prostitution ban followed her. Early penalties came from breach of contract, a fine, forced return, immediate freedom. Later, imperial rules standardized the remedy. Violate the prostitution clause and the woman gained automatic freedom, with the original seller as patron. Notice the asymmetry. Rome singled out sexual coercion with unusually strong legal tools when spelled out in advance. There were no equally standard clauses banning other forms of forced labour across the board. The system cared intensely about certain forms of exploitation it named. It cared far less about routine violence in fields, kitchens, shops, and mines. Why did these limits matter in daily reality? To answer that, we need to see the doorways in and out. People entered slavery through war captivity, through kidnapping and piracy on frontiers and sea lanes, through desperate sale by debt, and through birth to enslaved parents. Leaving was harder. Manumission could come through a master's will, through public ceremony with a rod called the vindicta, or by enrolment at a census. The Augustan rules narrowed those channels, but did not close them. After manumission, a freed person owed duties to the former master as patron. The bond carried expectations of respect and service. But the horizon opened. A freed person could marry, raise a family, own property, and in many cases gain limited citizenship. Some built wealth and left it to children. The hope of reaching that status made daily endurance possible. It was also a tool in the master's hand. Enforcement remained the long shadow behind every rule. A slave-in-law could not bring a case. Someone free had to carry the complaint. That meant finding a citizen willing to challenge an owner, absorbing the risk of conflict with a powerful household, and paying legal costs. Even testimony had barriers. Roman practice often demanded torture to test a slave's statement, a procedure that made truth-seeking cruel and unreliable. Add the social weight of elite networks, and you understand why most abuses never reached a magistrate. A rule carved on stone was one thing. A judge applying it to his neighbour's household was another. Public and private space framed how these laws worked. The domus, the Roman household, was a miniature state where the paterfamilias held sweeping authority. When discipline stayed inside, officials found it easier to look away. The laws that did emerge often targeted what spilled into public view. No arena executions without a judge. No spectacle of slaughter at a banquet. No practices the state deemed un-Roman when witnessed by a crowd. The message was consistent. Keep order. Avoid scandal. Do not force the city to watch what you do to your property. So why did limits arrive in the moments they did? Part of the answer is statecraft. The empire had to manage dense cities and sprawling estates without constant unrest. Trimming the sharpest edges of cruelty helped streets stay quiet. Part is ideology. Jurists wrote about moderation and the character of a good master. They valued the appearance of self-control, the reputation of measured authority. In the 4th century, another voice entered the legal conversation. Christian emperors spoke more darkly about killing. The rule allowing prosecution of a master's killing as murder fits that tone, but none of this overturned a system built on treating people as property. It added thin constraints the state could enforce when it chose to look. Let us gather the list plainly. A master needed judicial approval to send a slave to die with wild beasts in the arena. Castration was forbidden. Unjustified killing could bring penalties and damages. In the 4th century, intentional killing could be prosecuted as murder. Contract clauses could bind owners to free someone at a set time, or prevent manumission, or remove a person from a region, or ban prostitution, and violation of that last clause could free the woman automatically. These rules existed. They drew lines. They arrived late and left enormous ground untouched. The untouched ground defined most lives: the whip, the shackle, forced labour in fields and mines, sales that tore families apart, sexual coercion outside any written clause, days measured by someone else's will. The law's few constraints trimmed spectacle and signalled expected decorum. They did not transform ownership into stewardship or turn tools into citizens. Roman legal writers said the motive openly. These measures protected order, preserved the dignity of powerful households in the public eye, and defended the face of authority. If there is a paradox at the heart of these rules, it is this: a civilization confident enough to call a person a speaking tool also believed some forms of cruelty damaged the city's soul. The law did not ask who deserved kindness. It asked what behaviour kept the peace and preserved Rome's reputation. The limits we have traced did not spring from belief in universal personhood. They grew from a governing class managing a vast empire and its own image. That is why the famous stories and the dry legal clauses belong together. The banquet, where an emperor halted a killing, shows how public outrage could force a hand. The abandonment rule under Claudius shows how duty could be enforced when a master tried to walk away. The bans on castration and arena deaths show where Rome drew lines even inside private power. The murder rule under Constantine shows how intent became a crime. The contract clauses show how private agreements could trap an owner in obligations the state would enforce. None of these erased slavery. All made it slightly more legible to law and slightly more limited in its most visible horrors. So when we ask what masters could not do, the answer is narrow, concrete, and shockingly late. They could not stage certain deaths without a judge. They could not castrate. They could be punished for unjustified killing and later prosecuted for murder if intent was proven. They could be bound by contract to free someone, forbidden to free them, forced to relocate them, or barred from prostituting them, with real consequences for violation. The list is short, but it is not empty. It traces a civilization explaining to itself where discipline ended and scandal began, and it took Rome nearly 1,000 years to write even that much down.